As I've told you, if we wanted, we would have said all these applications have been filed out of time and we are not listening to them. Is that the situation you would have wanted? We have allowed, we are hearing them, although they are filed late. So let's make the best of the situation. Thank you.
My Lord, we go to the first application by the third respondent, which is to expunge 5 internal memos from the record. Those internal memos, my Lord, yes, there are 5 internal memos which we have applied to be expunged from the record. There is an affidavit in support and written submissions. Ms. Melissa Ngania will make the presentations on behalf of our team.
My ladies, my lords, the application before you is seeking to strike out and expunge the memos as pleaded in Part 1 of the application before you. The basis of seeking this request is that the memos were unlawfully and illegally obtained by the petitioners. My ladies, my lords, Section 27 of the IEBC Act provides for management of information. At clause 3, at clause 27.2, it provides for how information should be obtained from the Commission. It says a request shall be addressed to the Secretary or such other person. My ladies, my lords, in the memos that have been annexed in the petition before you, we see no such request to the Commission. The markings on the memos are clearly identified as internal memos. Without such request, a conclusion can be made as provided under Section 27 that such request was never made and therefore they are unlawful. My ladies, my lords, we would pray that they be expunged and not used in these proceedings. The use of them brings into jeopardy, first, the independence of the Commission to conduct its business. Article 80 of the Constitution provides for the independence, 88 of the Constitution provides for the independence of the Commission to dispense its business in providing a fair, credible elections. It is the song that has been pleaded in this petition. If that boundary is not drawn, then it will open the Commission to interference by parties who are actually players in an election. Furthermore, my ladies, my lords, the third respondent is a party herein. Using of this information is to the detriment of our clients. Article 50 provides for the right of fair hearing. This is information that is not in the public domain, but it has been come and challenge the election of our clients. We therefore pray that it be expunged from the record. My lords, if the Commission wanted the information to be within the public domain, then it would have published it in its website as provided under 27(1). The failure to provide that, it therefore means that it is not a public document, and that is why the right to information provided for under the Constitution is being provided for under 27(3). The Commission put that in mind, that people need to access information, and that is why we have Section 27(3), which says request for the information that you want to use. My ladies and my lords, that would be our reason why those documents should be expunged. Unless my ladies and my lords have any question, that will be our submission in respect to that application.
Thank you very much. Thank you very much.
I'm most obliged.
Yes. Mr. Ngatia, do you want to argue the other one so that Ms. Soweto can answer both of them together?
Yes.
Yes. I suppose that's okay with you, Ms. Soweto?
Yes, sir.
The second application, my lords, by the third respondent is seeking to strike out certain documents that were part of the petition. The deadline for filing the petition was 6th October. Those documents were part of that petition, but they were filed on 7th November, one day after the constitutional timeline. The fact that they were part of the petition is beyond argument. They are annexures, volumes, part of the document. I go volume 1 is part of an affidavit that was sworn by the first petitioner. The same is true for the second one and the next one and the third one. All these documents, my lords, were part of the petition. They were filed out of the 7 days. My lords, I do not need to overemphasize the fact that Article 140, Sub-Article 1, provides that a petition must be filed within 7 days. It is beyond argument the 7 days were to expire midnight on the 6th of October. So we do not have problems with calendar days. What the problem is, my lords, is the late filing of these documents which are part and parcel of the petition. In addition to that, my lord, the second prayer is seeking an affidavit that is referred to in paragraph 76 of the first petitioner's petition. My lords, when you go to paragraph 76 of the first petitioner's affidavit, there is reference to an affidavit by James Gondi. Gondi is Ngondi. That affidavit, even today, has never been filed or served. So that affidavit, my lord, we still retain it in that affidavit. The reference to it is still there. It causes confusion to the court, if I could say so with respect, because when you retire to write the judgment, you'll be looking for an affidavit which has never been part of the record. Also on our part, my lord, we must try to have a complete answer to the petition. It causes us difficulties that there is reference to an affidavit which is actually not part of the record. So the request to strike out that paragraph is to bring, so to speak, the reality with what has happened, which is that that paragraph does not exist. Prayer number 3, in the event, my lords, that you allow prayer number 1, which is to remove all the documents that were found out of time, then certain parts of the first petitioner's paragraph will be struck out, which is paragraph 74 and 75. The reason for that is because they speak to the documents we are applying to be struck out. Paragraph 74 and 75 speak to the paragraphs we have applied to be struck out. Equally, my lords, paragraph 30, 31, and 61 speak to paragraphs or documents that we have applied to be struck off. Sorry, my lord? 30, 31, 61 of Billy Atudo's affidavit, they speak to the documents that in prayer number 1, we have applied for them to be struck out. My lords, our application is supported by an affidavit, and we have also done written submissions. In the written submissions, my lords, we have referred to numerous, not numerous, but quite a number of authorities. I would wish, my lords, to emphasize the fact that these constitutional timelines do not call for extension. These are timelines set in the Constitution, and in our view, do not permit extensions as we understand them under domestic law and regulations. My lords, we have referred to an authority, a Court of Appeal decision in paragraph 4 of our written submissions, the Waitito judgment. We have also referred to other judgments, and, my lords, the totality of these judgments is that when statutory timelines have been set, the court should not entertain requests for extensions of time. I say all that, my lord, to preempt a request which has not been made. It is not a request before you.
The third respondent, and will not support that line. However, on the issue of expunging the letters, we do join the third respondent's concern.
Who are filed out of time, they affect you, and you're saying you have no objection because?
My reasons are very clear, my lord. We have all had problems in filing documents. There's been a long queue at the registry. To be dishonest of me. That's all.
Mr. Tangatia?
Yes.
Just before Soweto responds, with regard to the application to strike out the volumes, not the internal memos.
Yes.
The one seeking to strike out the volumes.
Yes.
We want to bring it to your attention that each council filing a petition is supposed to file 8 copies for the court, apart from the ones they are going to serve other parties. Of the 8 that are supposed to remain with the court so that they are distributed with the judges, we have 2 which are complete.
2 complete?
2 complete documents, including these volumes you are seeking to strike out.
So, I'm fair. Let me get this. 2 complete out of 8.
Let me put it again. Out of the 8 sets that are supposed to remain with the court.
Yes.
1 for each judge, and of course another 2 for the registry. 2 of them
Are complete.
are complete.
I agree.
They were filed with the documents, even the volumes you are seeking to strike out. So that's the position. Would you like to respond to that before Soweto stands?
Very well. Nonetheless, my lords, even those, if they were complete, I doubt whether they would have the affidavit of James Gondi
The affidavit of bond is not there. That one, you are right.
So we could actually now deal with it on the basis James Gondi's affidavit not there
Yes.
at all.
Yes.
So the reference to it ought to be deleted.
Yes.
And then we come to 2 out of 8. This is a very poor mark. If only they did 2 out of 8, they had others to serve on us, so it will mean only 2 volumes were complete out of so many other volumes. My lords, that, in my estimation, is not forgivable, because it will mean even 6 of the judges had incomplete sets. The position may have been different if all the court's copies were complete. But to allow a situation where 6 are incomplete, the one for councils are also incomplete, my lord, that is not a position that will be forgivable.